Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Denver, Colorado, and you're watching All Up in Your Business. In this episode of All Up in Your Business, I'm going to talk a little bit about the recent legal issues regarding the name of the Washington NFL team and tell you guys a little bit about why, from a legal standpoint, there is a little bit of a trademark issue here. And then also going to tell you guys a little bit about trademark squatting. But first, please be sure to like, subscribe, and share. And don't forget to check the description for more information and resources too. For example, if you need help getting a registered trademark, you can check out the details for my all-inclusive trademark registration package called Brand Bombshell. Or if you're on a tighter budget or one of these DIYers, check out Brandish, which is my on-demand online webinar that teaches you step-by-step how to get a registered trademark without a lawyer. All right, so a big story in the news recently has been this issue concerning the name of the Washington, D.C. NFL football team. They decided to change the name of the team because the previous name was it was outdated and offensive to large groups of people. So in the spirit of, equality and not offending people, they've decided to change the name. They were tossing around potential ideas like the Washington Red Tails, the Washington Warriors, the Washington Red Wolves, I believe was an option. There are all these different ideas kind of flying around, and people were speculating that these were potential names that the team was going to go with. Then came this big story that, someone has already trademarked all of those potential names. And in fact, it is true that one individual has filed trademark applications for something like 12 potential variations of possible names for the Washington football team. So does this mean that the football team is just completely SOL, totally out of luck when it comes to using any of those names? Because that's what we've kind of been hearing a lot in the news is, well, they were thinking about, the Red Tails or the Warriors, but now they can't because these names are trademarked. So is it really going to be an issue for the football team? No. Probably not. Mainly because the guy who filed these applications has already made it pretty clear that he wants to give the trademarks to the NFL team. He's not putting up a fight about it. So primarily, that's a big reason why this isn't really going to be a big issue for the football team. But that's certainly not the whole story. So a little bit of background on trademark law. In the United States and some other jurisdictions, we follow the first to use rule. Trademark rights in the US are based on first use. In many other countries, they go off of first to file, which means that trademark rights are based off of the first to file for a registered trademark. And so in these first to file jurisdictions, whoever files the application first is the winner. But in first use jurisdictions like the United States, the winner is the person who used the trademark first to use, regardless of if or when a trademark registration or trademark application was filed. And so in those situations, if a third party files a trademark application or gets a registered trademark for a trademark, but you actually have first use over that trademark, you can potentially petition to cancel that trademark registration because overall your rights are superior based off of first use. So, because of this, trademark registration and, trademark law and enforcement and rights aren't quite as black and white as they might be in a lot of other jurisdictions because it's a question of who used it first, not necessarily who filed it first. So often, if an issue arises, the parties will have to, produce documentation showing when they actually started using the trademark in commerce first, and there might be this disagreement or issue of who actually has first use, because we're not worried about who filed first. So now I've discussed in previous videos that you can file a trademark application on a 1A current use basis, which means that you're currently using the trademark in commerce, or you can file it on a 1B intent to use basis, which means that you're intending to use it. But the really important thing to remember, and this is going to be a big thing, you guys, so make sure you write this down. This is probably going to be one of the most genius and thoughtful and incredible things I've ever said. A trademark is not a trademark until it becomes a trademark. Did you catch that? A trademark isn't a trademark until it becomes a trademark. With an intent to use or 1B basis trademark application, the trademark won't actually be registered unless or until the applicant actually starts using it in commerce. There will be stages in the application process where the applicant has to submit proof that the trademark's now being used, and registration won't happen until it's actually being used. So in other words, an intent to use trademark isn't really a trademark at all because it's not being used. And you have to use a trademark to make it a trademark. So now going back to the whole trademark issue with the Washington football team name, if you do a little research or digging on these applications, you'll see that they're pretty much all filed on a 1B intent to use basis. That means the applicant hasn't actually started using the trademark yet, which means they're not actually trademarks yet. So this idea of this other person trademarked all these names and now the NFL or the football team can't get to them is kind of off base because, well, first of all, the person didn't trademark the names. There's pending applications for this trademark, but again, it's not a trademark until it's actually used. So it's just these pending kind of floating applications that may or may not become registered. So in and of themselves, these applications do very little to prevent Washington from using any of these potential names for the name of their football team. For example, if they started going by the Washington Red Tails and started, using that trademark in commerce before the applicant did, then the team could potentially oppose or somehow prevent those registrations from actually going through if they were to go through in the end. But the idea is that if the football team actually starts using the team name before this other person does, the football team has the trademark first, even though these applications exist. They're not trademarks. But the second issue here is what it actually means to file an application on an intent to use basis. And that's the part that really gets me steamed over news like this and stories like this. When we're filing an intent to use or 1B basis application, we have to certify, swear and promise and certify that we have a bona fide intent to use the trademark in the near future. An actual bona fide, legitimate, good faith intent. We are actually intending to use this trademark. It doesn't mean we just have an idea or a concept for a business. It means we're actually taking measurable steps to start using this trademark in commerce. We're promising that, we're swearing that in the trademark application. Now, I'm certainly not saying or trying to imply that the applicant who filed all these Washington Red Tails and all these different variations, all of those applications. I'm not trying to say that this person didn't have a bona fide intent. That very well could have been. I'm just saying it's a little curious that this person suddenly in the beginning of July 2020 decided that they had a bona fide intent to use Washington Red Tails, Washington Warriors, Washington Red Wolves, all in connection with entertainment and football games. So maybe there was a real intent there. I just think it's a little strange that that intent suddenly popped up all around the same day when the news of the team wanting to change their name came about, and that this person has this bona fide intent for all of these variations of the name, but whatever, that's not the point. This brings me to the idea of trademark squatting, or like trademark trolls. In a nutshell, a person who tries to get a trademark solely for the purpose of getting money out of somebody else. So if you see that this other party might be pursuing this trademark in the future, or they might have an interest in this in the future, filing an application or trying to get that trademark registered first so that you can then sell it to the other party or somehow make some money off of it. That's essentially what I'm referring to when I say trademark squatting. There are different variations of what people mean when they say trademark squatting. It comes up a lot in international trademark issues, like with China used to have a lot of trademark squatting issues, but I'm referring specifically to this kind of a situation where someone files or tries to get a trademark registered solely for the purpose of preventing another person or party from doing it, or to try to extort or get money out of them or something like that. If you're hearing all this news about Washington football team and their name and all the trademark issues, and if you're starting to get this idea for a great new business venture where you buy up trademarks to then try to sell them later, I'm here to tell you, don't do it. Reason number one, not to do it, it's not allowed. Like I said, you are swearing and promising and certifying and verifying that you actually have a bona fide intent to use this trademark in the future when you submit your application. Making false or misleading statements or saying something that's untrue on a trademark application is a federal offense, and it can be punishable by fines or imprisonment or both. So it's an actual crime, it's unlawful and illegal, and so that in itself should be hopefully reason enough not to do it. You can't, it's not allowed. Reason number two, it's probably not going to work out the way you think it will. Like I said, a trademark isn't a trademark until it's a trademark. So even if you don't get in any trouble by lying or maybe not being completely truthful on the application, you're still not going to get an actual trademark registration unless you start using the trademark. So if you're filing an application without the intent to actually use it and go through with the entire trademark registration process, then in the end, you're not going to end up with a trademark that you can sell or, hold against somebody. You're going to end up with an abandoned trademark application. So let's say I wanted to have a trademark registration for something new, but, I get wind that some trademark troll has already beat me to the punch and has filed an application for it. I'm not going to be too worried about it. I'm going to file my application anyway. My application will probably get suspended because of the prior pending application, which just means the examining attorney is going to put mine on hold while they see what happens with this other pending application, which is fine. So they'll put my application on hold, but then eventually this other party is going to need to start proving that they're actually using the trademark. And if they don't, then the trademark will be abandoned. And then they'll be out of the situation and my trademark registration will proceed as expected. So I wouldn't pay someone anything for that. If they're actually not going to be using the trademark, I'll just wait them out because they won't get a registered trademark in the end anyway. So to summarize all of this, does Washington's football team actually have a trademark issue with regard to their name? No, not really. This was kind of just a popular news story. Certainly an interesting thing for us to talk about, and interesting for me because it lets me talk to everybody more about trademarks in a relevant situation where people actually care. But in the end, I'm pretty sure that the football team's not going to have any problem using whatever variation of the name they choose. And can or should you take a tip from this guy who registered all these variations of the football team name? And should you try to start profiting off of trademarks in a similar way? No, you shouldn't. It's probably not going to work. And even if it does, it's most likely illegal. So there you go. That's all for this episode, folks. Drop a comment below. Let me know what you think. Like I said, don't forget to check the description for links to additional information, or if you want to learn more about my trademark registration services or my DIY online course, all of that info is in the description. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.